Friends, welcome back to my channel. Today I have come up with another important topic from the law of contracts, and that is the doctrine of frustration. The doctrine of frustration, it is related to the discharge of contract under the Indian Contract Act. So let's start. The doctrine of frustration of contract means the discharge of contract by reason of supervening impossibility or illegality of the act agreed to be done under the contract. Any contract between the parties, the performance of which was possible at the time of the contract, but subsequently the performance became impossible, and it is called the frustration of contract. So, under the doctrine of frustration, the performance of the contract becomes impossible to be done, and hence the contract gets frustrated. The doctrine of frustration is mentioned under section 56 of the Indian Contract Act. Now, let us understand this doctrine with the help of an example. A and B enters into a contract whereby B agreed to sell to A certain goods for rupees 1000. Those goods were coming in a ship, but before the goods could reach the destination, the ship sinks in the water and all the goods are destroyed. Now, B could not fulfill his promise to deliver those goods to A as they are destroyed in an accident. It is not due to the fault of B. Hence, the contract is discharged. It is known as frustration of contract. So, now as per this example, two parties, that is A and B, enters into a contract whereby B had agreed to deliver certain goods to A, and those goods were coming in a ship. Now the ship sinks in the water and the goods are destroyed, and B could not fulfill his promise to deliver those goods to A, and the incident occurred. It is an accident, and it was not in the hands of B to stop those goods from being destroyed. It was an accident. So, it was not due to the fault of B. Hence, the contract is discharged, and it is called the frustration of contract under the law of contracts. Now, the doctrine of frustration is based on the maxim "Lex non cogit ad impossibilia," which means the law does not compel a man to do what he cannot possibly perform. So, when in a contract the performance of the contract becomes impossible to be done, which are not in the hands of the parties, then the contract is discharged, that is, the contract gets frustrated, because we cannot expect a person to do something which cannot be possibly done. So, even the law, it does not compel a man to do what he cannot possibly do. So, this is the doctrine of frustration of contract. Now, coming to the reasons for the frustration of contract, like what are the conditions based on which we can say that a contract is frustrated. So, let us discuss this one by one. The first is the destruction of subject matter. So, if the subject matter of the contract is destroyed or becomes impossible, it will lead to frustration of contract. As in the example mentioned just now, like where two parties A and B agreed to enter into a contract, and whereby B agreed to deliver to A certain goods, and those goods, they were destroyed in an accident because those goods were coming in a ship, and the ship sinks in the water and the goods are destroyed, and hence B became impossible to perform his part of the contract to deliver those goods to A. Hence, the contract is discharged, and the contract gets frustrated, and that is known as the frustration of contract. So, destruction of the subject matter of the contract, in that particular example, the goods which were the subject matter of the contract, the goods to be delivered, were destroyed in an accident, and the contract was discharged, leading to the frustration of contract. The second condition or the second reason for the frustration of contract is supervening illegality. Suppose if any situation arises which makes the contract illegal, it will become a frustrated contract. For example, two persons from two different countries, they made a contract with each other. But before the performance of that particular contract, war started between those two particular countries, and the performance of the contract became impossible, and the contract will be frustrated. The third reason of the frustration of contract may be death or incapacity of a party. So, if either party to a contract dies or becomes incapable to perform the contract, then the contract will be frustrated automatically. For example, A and B enters into a contract whereby A agreed to sell certain things to B. Now, before the contract was performed, A died. So one of the parties to the contract died. Now after the death of A, the contract is discharged. The contract is frustrated automatically because one of the parties to the contract died before the performance of the contract. Similarly, another example, A and B enters into a contract whereby A agreed to perform for B in an event. Now on the date of that particular event, A became ill and he could not deliver his performance. So A failed to deliver his promise on that particular day because he was ill. Since he was ill, he became incapable of performing his part of the contract. So the contract is frustrated. The contract is discharged because the party who had promised to deliver something, to deliver his performance on a particular day for B, became incapable of performing on that particular day due to his illness. So death or incapacity of a party is another reason for the frustration of contract. Now, another reason for the frustration of contract may be non-occurrence of the event. For example, if a contract between two parties is based on an event or is based on an event to be happened and that event becomes impossible to happen, then that particular contract will become void. That particular contract will be discharged when the occurrence of that particular event becomes impossible. So that contract will be frustrated automatically. Another reason for the frustration of a contract is by virtue of legislation, where a law promulgated after the contract is made makes the performance of an agreement impossible, then the contract is first frustrated. For example, A and B enters into an agreement for certain thing, and after that contract was agreement was entered into, a certain law was passed which made the performance of that agreement impossible. Then that particular contract is frustrated automatically. So another reason for the frustration of contract is by virtue of a legislation which makes the performance of certain contract impossible. So these were the reasons for the frustration of contract. In a nutshell, I am repeating the reasons for the frustration. The first is destruction of the subject matter of the contract. The second is supervening illegality. The third is death or incapacity of the parties. The fourth is non-occurrence of an event. And the fifth is by virtue of a legislation. Now coming to the effect of frustration of contract. What happens when a contract is frustrated? So once the contract is frustrated, the contract is discharged automatically. The obligations of the parties gets terminated immediately once the contract is frustrated, and both the parties to the contract are discharged from any further obligations. So this is the effect of frustration. Now, when we are talking about the doctrine of frustration, then one of the case laws which is very important is the case of Saityabrata Ghosh versus Mugniram. In this case, the Supreme Court of India talked about the doctrine of frustration. So let us know what the court exactly said in this case. Justice Mukherjee, in the case of Saityabrata Ghosh versus Mugniram, held that the essential element upon which the doctrine of frustration is based is that of impossibility of performance of the contract. It was further held that the changed circumstances make the performance of the contract impossible and the parties are absolved from the further performance of the contract as they did not promise to perform an impossibility. The doctrine of frustration is really an aspect or part of the law of discharge of contract by reason of supervening impossibility or illegality of the act agreed to be done. Hence, the court held that the doctrine of frustration comes within the purview of section 56 of the Indian Contract Act 1872. So, all this was held in the case of Saityabrata Ghosh versus Mugniram by the Supreme Court of India. So, this was all about the doctrine of frustration under the law of contracts, and in my next video, I will come up with another important topic from the law of contracts. Thank you for listening, and if you like the content of my videos, please subscribe to my channel and do like and share the videos. Thank you.